Here is Officer Darren Wilson's explanation today to George Stephanopoulos of why he shot and killed Michael Brown.
You say he starts to run, does a stutter step, starts to come towards you, and?
At that time, I gave myself another mental check. Can I shoot this guy? Legally, can I? And the question I answered myself was, I have to. If I don't, he will kill me if he gets to me.
Even though he's, what, 35, 40 feet away?
Once he's come in that direction, if he hasn't stopped yet, when's he gonna stop?
If American police officers shot every unarmed person who runs at them, we would have thousands and thousands and thousands more dead Americans killed by police every year. Darren Wilson knew that Michael Brown was unarmed. He knew Michael Brown was wounded. He knew, or should have known, that Michael Brown was no longer physically capable of being a threat to his life. And that is the legal standard that Darren Wilson knew he had to meet in order to convince the grand jury not to indict him. He had to make grand jurors believe that, at least in his mind, at least he believed that unarmed Michael Brown, even though he'd already been shot 4 times, was somehow going to kill Darren Wilson from a distance of 35 feet away. And so to save his own life, he had to shoot Michael Brown in the head. There is no real reason to believe Officer Wilson's story that Michael Brown was charging at him, but even if you do believe it, there is certainly no reason to believe that Officer Wilson could not have easily avoided being tackled by someone who's been hit by 4 of his bullets. You don't have to be an NFL running back to avoid that tackle. But was Michael Brown actually charging Officer Wilson? That is one of the most important questions in this case.
One describes his movement toward Officer Wilson as a full charge.
That was District Attorney Bob McCulloch last night mentioning the only witness who he thought worthy of quoting in his nationally televised announcement of no indictment. No other witness was singled out by the prosecutor. That witness, identified in the grand jury and police reports as witness number 10, is the only witness whose description of Michael Brown's movements agrees with Officer Wilson's description completely. Without that one witness to corroborate Darren Wilson's description of Michael Brown's movements, Darren Wilson might not be a free man tonight. That's how important that witness was. That's why the prosecutor cited him individually last night. For the prosecutor to lean that heavily on that one witness, witness number 10, must be the most consistent and credible of the eyewitnesses, right? Witness number 10 must not be one of those witnesses who changed his story or got things wrong.
Eyewitness accounts must always be challenged and compared against the physical evidence. Many witnesses to the shooting of Michael Brown made statements inconsistent with other statements they made and also conflicting with the physical evidence.
So witness number 10 must have survived that challenge by the investigators and the district attorney. As an example of how this grand jury investigation actually worked, let's examine the credibility of this one crucial eyewitness, the only one who agrees with Darren Wilson's full description of Michael Brown's movements after the confrontation at the police car. Witness number 10's police interview just 2 days after the killing of Michael Brown, when his memory was fresh, begins with the detective saying, "Would you just retell your account of what took place?" Retell, of course, means he already told his story at least once to the police without being recorded. So there is no way of knowing just how consistent his police statement, which is at least his second statement, is with whatever his unrecorded first statement was. Witness number 10 was working in the neighborhood, and he begins his story to the police with, "I seen the 2 young guys walking down the street on the same sidewalk that I was on." 6 weeks later, witness number 10 testified to the grand jury and changed his story about where Michael Brown was walking. He said under oath to the grand jury, "I seen Mike Brown and his friend walking down the street closer to the curb, not on the sidewalk." By that time, the basic fact that Michael Brown and his friend Dorian Johnson were walking in the middle of the street had become well known. It was the very reason Officer Wilson stopped to confront them. The police and Michael Brown's friend Dorian Johnson agreed that Michael Brown and Dorian Johnson were walking in the middle of the street. And witness number 10, who said they were walking on the same sidewalk with him 6 weeks ago, changed his testimony to they were walking down the street, closer to the curb, not on the sidewalk. That is the kind of thing the district attorney was complaining about last night, witnesses changing their stories to fit the publicly known facts. Here is why witness number 10 was the most important witness to appear in Darren Wilson's defense. This is what he described Michael Brown doing when Officer Wilson got out of the car and chased him. Michael Brown stopped. He did turn. He did some sort of body gesture. I'm not sure what it was, but I know it was a body gesture. I could say for sure he never put his hands up after he did his body gesture. He ran towards the officer full charge. So there's witness number 10 saying the magic words. He never put his hands up and he ran towards the officer full charge. In the grand jury, when the prosecutor asked witness number 10 to describe what he called a body gesture, he said, "I can't say for sure what sort of body gesture. I cannot fully recall. All I know is it was not in a surrendering motion of I'm surrendering, putting my hands up or anything. I'm not sure if it was like a shoulder shrug or him pulling his pants up. I'm not sure." So there's the district attorney's favorite witness, the only one he quoted last night, saying, "I cannot fully recall. I'm not sure. I'm not sure," within the body of an answer in which the only thing he's absolutely sure of is that Michael Brown did not do a surrendering motion. In a real courtroom, when a witness begins his answer with, "I can't say for sure," and then in the body of his answer he says, "I cannot recall fully," and then says, "I am not sure," twice within that same answer, that witness observation does not survive cross-examination. But there was no cross-examination in the grand jury room. This is about as challenging as the prosecutor got with witness number 10. Question, let me ask you this. How is your vision? Witness number 10, pretty good. Question, do you wear glasses or contacts? Witness number 10, no. He was not then asked, when was your last eye examination? Have you ever in your life had your eyes examined? We have no idea how old this witness is. Is witness number 10 in his 60s or 70s and watching this without needing eyeglasses? Is he in his 20s? We have no idea. But we do know how good his eyes have to be to offer the grand jury the precise observations he did. In his police interview 2 days after the killing of Michael Brown, he was asked how far away he was from the action that he was watching, and he said, quote, "To guess, maybe 100 yards, I would say, maybe less." So the district attorney's favorite witness, the most effective witness for the defense of Officer Wilson, told the police that he saw everything clearly, without eyeglasses, from 100 yards away. Stop. Think about that. There's a football field with the referee on one goal line, and the action he is judging 100 yards away at the other goal line. Who among you would trust the judgment of that referee standing on one goal line 100 yards away from the action at the other goal line? Anyone who's ever seen a football game, as we can assume the district attorney of St. Louis County has, would not put much faith in the observations of a referee who was 100 yards away from the play. And witness number 10 is the most important referee of what happened in the killing of Michael Brown, as far as the district attorney is concerned. He made that clear last night, quoting only witness number 10. How far away was witness number 10 is the most important credibility point we need to know in evaluating his testimony. 6 weeks after saying he was 100 yards away watching the action, he was asked in the grand jury room under oath how far away he was when he was from what he was watching, and he said, "I would give it 50 to 75 yards." He cut the distance in half to 50 yards just like that. He did that under oath before a grand jury who had no idea that the last time he was asked that question 2 days after the shooting, he said double that. He said 100 yards. And no prosecutor in that grand jury room put his police interview transcript in front of him and asked him if he remembered saying 100 yards instead of 50 yards. No prosecutor in that room let the grand jury know that witness number 10 was changing his story under oath about how far away from the action he was. How honest is witness number 10? Is there anything we know about his background that could help us with assessing his integrity? No. We know nothing about his background. He may be living a completely admirable and honorable life. He may have done his very best to tell the truth each time he told his story, even though it changed. Or he may be eager to do police a big favor for all sorts of possible reasons. We don't know. We don't know anything about him. Did he smoke dope when he was a teenager like Michael Brown? We don't know. Does he have a criminal record? We don't know. We've never seen him. He has never come forward publicly. We know nothing about his background, but the district attorney thought that he was the only witness worth quoting because he was obviously the prosecutor's most important witness in justifying bringing no charges against Officer Wilson. In a case with such intense public interest as this one, we would like to be able to judge the credibility of all the witnesses. We would all like to be able to do that. We would like to know as much as we can about them. But what we know about witness number 10 is that the prosecutors willfully did absolutely nothing to help the grand jurors judge the reliability of the only witness who completely agreed with Darren Wilson's description of what Michael Brown's movements were, a description he offered from his vantage point of 100 yards away. Or was it 50? Lisa Bloom and Jim Kavanaugh are here. They're going to react to some of this evidence next. Stay with us.